Congratulations to you.
Thank you.
I'm just going to ask you about one case because it raises some questions in my mind. I just kind of want to know your thinking. This is the Albertus Lewis case. He murdered a person by the name of Maya Sanchez and left her outside the hospital door after he shot her. You originally denied bond, and then for some reason you granted bond. I know the case received some attention when you were nominated to the state appellate court. In an interview with a newspaper, you cited, quote unquote, constitutional issues of detention without trial. Unfortunately, while he was out on bond, the police allegedly responded to several domestic violence scenes involving him. At the last one, he used a child as a human shield during a shootout with sheriffs. So is the constitutional issue you referred to the right to a speedy trial under speedy trial clause?
Thank you, Senator. And I'm going to be very careful on how I answer because that case is still pending. Although it is a 2017 case, that case is still pending. He is not, I don't believe he's been convicted of any of those charges. What I will tell you is a public record. He appeared before me for a bond hearing, and I denied his bond. It was not until after, I believe, 18 months or 2 years later, that after being ordered to try his case, the state being ordered to try his case, that I granted bond because of a violation of the court's order and also a potential violation of the Sixth Amendment right to a speedy trial.
Can you tell me what remedies courts have identified for speedy trial clause abuse violations?
Thank you, Senator. The remedy for a violation of a speedy trial is usually dismissal of the charge. I did not dismiss the charge. I granted a significantly high bond in lieu of dismissing the charges.
Since you didn't do it for dismissal, and you said, I think you would agree that dismissal is the only reason it can be used for a remedy in that instance, right? Did Mr. Lewis raise the speedy trial clause in his motion?
He, if I recall, there was an order from a previous court in which a judge had ordered the state to try his case. So there was an order from the court, and I believe I found I made my decision based on the violation of that order. He also claimed that his Sixth Amendment rights were violated.
What factors do courts consider in deciding the right to a speedy trial has been violated?
Thank you, Senator. Courts consider the duration of the time that the defendant was detained, the reason that the state has given for the delay in trying the case. In that case, Senator, there was no reason given for the delay. There were issues of discovery violations, and therefore I found that it was appropriate to issue a significantly high bond.
Okay, move on to another issue. We always try to get people, particularly if you've been a judge, to kind of describe to us your judicial philosophy. And I'm particularly interested in how you would approach the Constitution.
Thank you, Senator. Over the course of my career, I was on the municipal court for 7 years. I've been on the state, South Carolina State Circuit Court for 11 and a half years. I approach each case individually. I look at the facts of the case, I consider the evidence in the case, and then I rule based on the case that is before me. In considering the Constitution of the United States, Senator, I would consider the text of the Constitution. I would use any evidence, any historical evidence to gain an understanding of the drafter's intent at the time that the Constitution was drafted.
So then it seems to me you've kind of described yourself as an originalist. Is that right?
Well, Senator, over the course of my career, I've tried not to ascribe to any titles, but that is the approach that I've taken.
Thank you.
Thanks, Senator.